Call the meeting to order just a few minutes late. Sorry about that, everyone. First off, I'd like to ask for approval of the minutes from February 6th. Everybody should have a copy. Do I have a motion? We have a motion from Representative Penn, and my ranking member here does the second on it. Any discussion on the minutes from February 6th? Not seeing any. Do I hear anybody in for it? Please say aye. Aye. Sorry about that. Anybody opposed? All right, minutes are passed. Let's move on here. I'd like to open a hearing on 2589. If I could get the reviser to give us a brief explanation. Thank you, Nick.
Yeah, you're welcome, Mr. Chairman. Sorry, I'm still in K through 12 education budget mode. Yes, Mr. Chair and members of the committee. House Bill 2589 would enact a new section of law to authorize any public utility, and this includes any municipal public utility or any electric cooperative public utility, to enter into a pole attachment agreement, is what it's called under this bill, with a law enforcement agency, so that the law enforcement agency can attach and operate law enforcement equipment on utility poles located in the public right-of-way. So the bill specifies what this pole attachment agreement would be required to include, and it would be required to identify the utility poles in the public right-of-way that where that equipment can be attached. It would have to specify the nature of that law enforcement equipment, essentially describing the size and the type of equipment that would be attached. It would also have to establish safety specifications for attaching and accessing and operating that, and also removing that equipment. And then it would also require, as part of this agreement, to the law enforcement agency to indemnify, defend, and hold harmless the public utility from and against all liability relating to the public utility's actions relating to the pole attachment agreement. In addition, the bill would authorize a public utility to assess reasonable fees or charges to recover the actual costs that are incurred by the public utility for the attachment, maintenance, or removal of any law enforcement equipment. That would be in the case if the public utility is attaching, maintaining, or removing the equipment. And then lastly, Mr. Chair and committee, the bill would establish that any public utility that enters into a pole attachment agreement would be considered an instrumentality of a governmental entity under the Tort Claims Act. And then also, if a law enforcement agency is held liable for any claim relating to a law enforcement agency's activities related to the pole attachment and the equipment that's on the pole, the law enforcement agency would be required to indemnify the public utility for all claims arising out of the attachment or operation of that law enforcement equipment. And Mr. Chair and members of the committee, the bill would take effect, if enacted, on July 1 of 2024. And I'd be happy to stand for questions.
Thank you, Nick. Any questions throughout the committee? Representative Carmichael.
Thank you, Mr. Chair. While I have concerns about this bill, I have a specific difficulty understanding why immunity provisions are necessary here. Kansas is a comparative fault state, meaning that you're only responsible for your own percentage of negligence. Can you explain to us what the function of an indemnification clause in the law would be in a comparative fault state where there is not implied comparative indemnity and a number of other things?
Yeah, so this indemnification provision in the law that I just stated at the very end of my brief, remember that it requires that if a law enforcement agency is held liable for any claims relating to the law enforcement agency's activities, then the indemnification provision would kick in. So I think the key there would be the liability of the law enforcement agency. I think the other hurdle, notwithstanding the indemnity provision, would be for some type of lawsuit to come onto the utility side, would be the provision relating to the Tort Claims Act, where the utility is deemed an instrumentality of the state under the Tort Claims Act. And there might be some exception to liability under the Tort Claims Act that gets claimed.
I don't want to belabor the indemnification because we've got a lot of things to consider on today's docket. But my recollection of the Tort Claims Act is, and I'm sorry I didn't prep you for this question, but the Tort Claims Act limits liability to no more than $500,000 unless the instrumentality, if you will, has insurance insuring it for more. So it sounds to me like Evergy, for example, if somehow they were held liable, would be subject to the Tort Claims Act limitation of $500,000. But if Evergy went out, as I hope and presume they did, and bought $20 million worth of insurance, there'd be $20 million of exposure under the Tort Claims Act. Am I tracking that, or are we too deep into the weeds of the Tort Claims Act for this morning?
Well, you might not be too deep in the weeds, but that's something that I would need to do some more research on to give you guys a good response on that.
If time permits, before we work the bill, if you could at least let me know, or perhaps the chair, if the committee wants to know about how that would work. Thank you.
Certainly.
Thank you, Representative. Good question. Mr. Schreiber.
Thank you, Mr. Chair, and thank you, Nick. I just want to be clear on where this will be allowed. So easements that are acquired for transmission and so forth would not be considered a public right of way, and so they wouldn't be allowed on those type of transmission structures. Is that, am I understanding it correctly?
Yes. Yes. So the public right of way is defined in the bill, and it's only the area of real property in which the city, county, or state has a dedicated or acquired public right of way interest in the property. And then it goes on to provide a little extra clarity there. But yes, private easements, leases, that type of thing for any transmission would not be included within the public right of way definition under this bill.
Okay. Thank you, Mr. Chair.
Representative Turner.
Thank you, Mr. Chair. My question is also on the indemnification. So it talks about liability related to law enforcement activities. But what if the device just falls off and hits someone on the ground? Is that indemnified against claim?
Again, the indemnification provision of the bill does state that there has to be liability. You have to find liability on the law enforcement agency in order for that to kick in. So the law enforcement agency has to be liable for law enforcement activities that are occurring with regard to this equipment that's on the utility pole. And probably, I'm envisioning this would come through a Section 1983 action challenging a constitutional rights violation where the law enforcement agency is becomes subject to a suit under that action. I also envision there might be within this pole attachment agreement some attorneys for the utility companies structuring their own indemnification provisions with regard to kind of the situations you're describing, just depending on how the agreements are negotiated and structured.
But that's not in this bill. This bill indemnifies law enforcement activity claims. So it's still a bit unclear to me.
Yeah, indemnification happens when law enforcement is liable for a law enforcement activity. The utility is indemnified for any claims related thereto, and then you're probably subject to the agreement.
Committee, any other questions? Okay, not seeing any. Thank you, Nick. First up, we've got Joseph Sullivan, who's the chief of police for Wichita. He's also got with him Sergeant Brian Safras for technical questions, as I understand. But to both of you, welcome. Thanks for making the trip up here today. I do appreciate it, and welcome to the committee.
A pleasure. Thank you for allowing us the opportunity to be here this morning on this very important matter. I am Chief Joe Sullivan, Chief of the Wichita Police Department. I am honored to provide testimony in support of the deployment of the law enforcement equipment on utility poles and the proposition in front of you today. As the chief of police of the largest city in Kansas and a member of law enforcement for the past 4 decades, I want to emphasize the critical importance of leveraging utility poles as a strategic asset for enhancing public safety, improving response capabilities, combating crime effectively, and saving lives. Using utility poles as platforms for law enforcement equipment offers multiple advantages to extend their reach, enhance situational awareness, deter criminal activity, and again, save lives. I would like to highlight several key reasons why the deployment of law enforcement equipment on utility poles is essential for effective modern policing. First, utility poles provide elevated vantage points that enable cameras and license plate readers to capture wide-ranging views of public spaces, thoroughfares, and critical infrastructure. This increased visibility deters criminal activity, enhances situational awareness, and allows for a more rapid and targeted response to incidents. Second, law enforcement agencies can strategically intentionally position data-driven technology equipment on utility poles to target specific areas of concern. Third, leveraging utility poles as platforms for law enforcement equipment represents a cost-effective and scalable solution for enhancing public safety. Fourth, this proposal encourages collaboration between law enforcement agencies and utility providers, which minimizes disruption to communities and maximizes the efficiency and effectiveness of public safety initiatives. Fifth, this proposal provides essential legal protections and risk mitigation for both utility providers and law enforcement agencies. I would also like to highlight some of the technology that is included in the public safety equipment that we are planning to utilize, including license plate recognition or LPR technology, which has proven time and time and again to be an enormously beneficial asset for law enforcement and homeland security operations for nearly 20 years. Since November of 2020, the Wichita Police Department LPR program has led to the recovery of over 400 stolen vehicles, totaling over $5 million in value, the seizure of 56 guns used in crimes, and making numerous violent crime arrests, locating kidnapping victims and missing persons. Using LPR technology, our officers have located missing juveniles, cleared silver alerts, solved homicide investigations, and quickly recovered stolen property. An example of where LPR technology was critical was a silver alert where a 74-year-old female diagnosed with this dementia went missing. Her car tag was entered into the system, and 9 hours later, she was located lost in a field 13 miles away from her house. Without that technology on a utility pole, she may never have been located alive. Another example, in 2016, officers used LPR technology in a homicide investigation where a baby was kidnapped and taken to Texas after her mother was killed. LPR technology determined that the suspect had left Kansas. Investigators were eventually able to locate the kidnapper in Texas and the baby and the baby was returned safely to her family. These are but two examples out of the incidents that occur hourly in our city. Our department's homicide section has an astounding 95% clearance rate in 2023. This is in a large part due to the use of LPR technology in their investigations. Homicide investigators review LPR data on nearly every homicide, and many times they garner leads they would not have found otherwise. Turning to the important consideration of personal data protection and transparency, we are committed to respecting the individual's privacy rights and compliance to all applicable laws and regulations. Clear policies and procedures are in place to ensure that technologies are used responsibly and with transparency and with appropriate safeguards to protect each individual's privacy and civil liberties. Data is housed for 30 days only and may only be accessed for specific anticipated reasons. I'm sorry, articulated reasons. Rigorous data security measures, including encryption protocols, access controls through legitimate law enforcement purposes, data retention policies, and regular audits are implemented to safeguard sensitive information from unauthorized access or misuse. My department has demonstrated that it is committed to actively engaging with community members to solicit feedback, address any privacy or transparency concerns, and we will continue our public outreach efforts to ensure that community members are informed about the purpose, scope, and impact of data-driven technologies that serve the interest of all of our residents. In conclusion, the deployment of law enforcement equipment on utility poles represents a key part of intelligence and data-driven policing. By harnessing the capabilities of utility infrastructure in partnership with utility providers, law enforcement agencies can maximize the impact of public safety initiatives. Thank you for your interest and attention to this important matter, and I am available to provide further information or answers to any questions that you may have.
Thank you for your testimony, Chief. Questions? I'm going to start with Representative Carmichael.
Thank you, Mr. Chair. It's getting so bad I don't even have to raise my finger anymore. Chief Sullivan, first I want to express my appreciation to Captain Slaughter of your department, who contacted me night before last, well after hours, as he was preparing to leave the city on vacation, and he assured me that he wanted to be here to answer questions today, and that he's worked with the program now in Wichita for 4 or 5 years. And I certainly want you to understand that I appreciate his dedication to duty, even though he and I disagree on this particular issue. The cameras, for example, that we're talking about, a lot of them are known as Flock, F-L-O-C-K, Flock, a particular manufacturer, if you will, cameras, correct?
That's correct.
And I recognize that it can be a valuable tool in law enforcement, but I'm sure you also recognize that if misused, it can be 1984 Big Brother. Can we agree?
Absolutely.
And you told us that your department has implemented rigorous protocols to protect the safety, privacy, and security of the data gathered by these cameras, correct?
That is correct.
But as you know, there have been at least one very serious breach of the security on your Flock system. A KeyChi officer used your Flock data records to surveil his ex-wife, and unfortunately, it wasn't detected by your auditing. Rather, it was detected by a detective with your department working a stalking complaint who figured out that somebody was accessing Flock, and then you looked at the records and figured out it was a lieutenant on the KeyChi Police Department. You generally aware of that sequence of events, Chief?
I am.
And to make the situation worse, law enforcement agencies from all over the United States now have direct access to your agency's Flock data. Places like Farmington, Missouri, St. Louis, Missouri. I can go through it. Wausau, Wisconsin. I mean, there's 40 or 50 or 60 of them listed on the Flock website that have direct access to video cameras in Wichita, Kansas. What steps are you taking to secure this data to keep rogue officers in Farmington, Missouri from searching for my license tag number to see if I'm having a relationship with their girlfriend in Wichita, Kansas?
Well, I will speak to that, and Sergeant Saffers behind me will contribute to that even further. But we do regular audits. There are protocols in place where, in order to sign into the system, first of all, you have to sign into the system. You have to indicate the nature of the crime that you are investigating. You have to provide a case number. And that's why we conduct those audits regularly. And whenever we find a discrepancy, we require a response. Well aware of the incident in KeyChi. But what I would say to you that particular former officer was prosecuted, he was fired, and he will never be a police officer in the state of Kansas again. His certification was taken away from him. So I think that was addressed in an appropriate manner, and I think that one incident also demonstrated that when the complaint was received, we utilized flock technology to put together that prosecution, and we had the data because of the flock. I would also say to you that one incident, as serious and disappointing as it was, does not. This is just the success stories in Wichita. That one incident does not take away from the fact that people expect us, when a member of their family is killed or seriously injured, to have the technology and the ability to solve that crime. And we would not have a 95% clearance rate for a homicide in the city of Wichita if it was not for that technology. I have literally been on scene of homicides where Captain Slaughter has pulled out his computer and he has signed in the appropriate way, with the appropriate protocols, and he has identified the car so that we were able by the end of the day to have someone in custody for that homicide before they committed another homicide, which is why the clearance rate is what it is. When we have one homicide, our priority is always what is going to be the next homicide. So, and I can have Sergeant Saffers come up and take everyone through the exact security protocols that you must go through to sign on to the system, and how those regular spot audits are done, and the action we take. We find members of our department that have conducted procedural errors, but every time they have signed on to the system, it has been in furtherance of a criminal investigation. It is procedural error, never one that involves misuse of the system.
Mr. Chairman, I appreciate the chief's filibuster, but the fact of the matter is they haven't made any changes to these security protocols following the serious breach of the system, and citizens are at risk because of their failure to do
Well, that is not true. There was a change to the sign-on to get onto the system as a result of that. And that was with the cooperation and the recommendation and the support of Flock. And that new sign-on is for everyone in the system, not just for the members of the Wichita Police
The
Department.
records are still accessible by law enforcement agencies all over the country, and they all get the sign on to do it. The incident in Keachai was not because of a failure of a sign on. It was because of a failure of the Wichita Police Department to timely audit the accesses and the reasons for those access. And it wasn't found because of your security protocols. It was caused by a detective using detective techniques to figure out why it was that a victim of stalking, her location was known to her ex-husband. And so I think you've got serious problems with this, Chief. Thank you.
I don't think one incident is a serious problem, sir.
Stop this debate now. I'm going to move on to the next question. Thank you both. Appreciate it. Representative Proctor.
Thank you, Mr. Chair, and thank you, Chief, for being here today, and thank you for your service. So I share some concerns about not the security of the data, but misuse of the data by law enforcement. Not your agency, but once it's out there, it can be used by anybody. And I won't belabor you with that. I'm working on some information sovereignty legislation I'll be bringing next year, but what the question I'd like to ask you is, what is the check and balance for where and when you put surveillance technology on one of these utility poles? If this bill passes and you get that authority, is it you have the money to do it and you want to put it there, or is there some review process by elected officials?
Well, certainly the Flock program was approved by the elected officials in Wichita. As far as where we choose to place Flock cameras, and again, these are ALPR cameras that are taking pictures of license plates. They're not continuously recording surveillance cameras. And we only access them when we're to try to identify a vehicle leaving the scene of a crime or present or determine that someone was at the scene of a crime. That information is purged every 30 days. So that information is not in perpetuity. So if we do not have a need to use it within 30 days, it is purged from the system and is no longer accessible.
So once this program is approved by elected officials for you to spend the money on Flock, it's at your discretion where and how many cameras, these cameras you put up?
We discuss all of this with our elected officials. So we increase the number of cameras, which is our intent to do so, commensurate with development of real-time crime center.
Yeah.
And Sergeant Saffers here is my technical expert, who is part of that project that will go out to public review. We will be out in the community demonstrating what is our intention and what is our plan. How do we reach these decisions? Our decisions, our crime analyst section determines, takes a data-driven approach by looking at violent crime and how it's emerging, not just this year, but over 5 years, determine where it makes the most sense to place these cameras. We'll be looking at we'll be looking at crime, we'll be looking at fatal auto accidents, leaving the scene accidents, a full spectrum of public safety issues to determine where they have the most value to make Wichita safe.
And I want to be clear, I'm not concerned that your department would misuse the data. What I'm concerned about is once you've got this huge cache of big data, there's all kinds of pattern matching things that you can do using machine learning that would basically create reasonable suspicion just based on pattern matching rather than actually folks committing crimes. But I appreciate.
I just want you to know that we don't proactively go into the system. We go in there reactively.
I'm not worried about you.
Okay,
I'm worried about the FBI. I'm worried about the federal government. When catastrophes happen, people stop caring about their civil liberties and just want to be made safe. And that's when abuses happen. That's historically been the case. And I'm not worried about you. I'm worried about other people having access to your data.
But I can promise you that we wouldn't give anybody access to our data unless they demonstrated an appropriate, legitimate law enforcement need. They would have to be a case that was under investigation.
Thank you, Chief. Thank you, Mr. Chair.
Thank you, Representative. I'd like to go to my Vice Chair, Representative Turner.
Thank you, Mr. Chair, and thank you for being here and the work that you do. As I look at testimony, you appear to be the only person from the city that's here, and you've given us the law enforcement point of view. But I wonder how much were the city attorneys involved in negotiating this, and have they signed off on the indemnification of liability?
They were involved in our drafting of this legislation. I can't answer that second question. That's a legal question. So if I had known, I would have asked one of our city attorneys to accompany me. So I apologize for that.
But there's no testimony here of their voice, but you're saying that they're on board and they're good with the language that's in this bill?
That's correct.
Representative. Oh, there you are. You're hiding on me down there. Representative Schmidt.
Thank you, Mr. Chair. Thanks, Chief. Chief, Wichita's a big town. How many cameras do you have?
We have 190 Gentech cameras. They are actually cameras that record at intersections. They are not covert. They are obvious to the public. Flock cameras, we have 161.
The program sounds awesome to me, and I really appreciate what you're doing. So thank you very much.
Representative Shalane Sapin.
Thank you, Mr. Chair. Thank you, Chief Sullivan. Who installs the cameras and who maintains the cameras that are on the poles?
I'll try to answer that for you. How are you? Flock will come out. They'll send out a team that actually installs cameras. Initially, when these were started, they were.
Sir, can I stop you just a second?
Yeah.
You're fine. I just need to have you announce who you are, because there's people
I'm
watching.
Sergeant Brian Saffers. I work for the Wichita Police Department.
There you go. Thank you.
I've been involved in the project quite extensively. So Flock would send out a maintenance crew that would come out and do a site survey. They will also pull permits, make sure that everything is fine. Once the site survey is done, they come back out, install a pole, or put it on a utility pole.
So if I may follow up, the utility workers themselves are not involved in the installation or the maintenance of this equipment.
Correct. It's the company.
We only have a written statement here from line workers, I understand, or managers who claim there's a risk to them to be doing this installation. So my question, really what I'm leading to, is to ask, are they involved in this process? Number one, and two, have there been any known kind of cases you're aware of in which those workers felt insecure because of their participation in the installation of such technology?
No, I've actually been out on installs and actually been trained to move and install cameras myself, or the LPRs and the solar panels. So no, I've never had anything like that conveyed to me that it was unsafe. Or
Thank you, Mr.
Kind of a follow-up to your question. We've got Evergy here, and I'm going to call him up and that'd be a good question for him. All right. Representative Penn.
Thank you, Mr. Chairman. In the interest of time, I'll be as brief as possible. Chief Sullivan.
Morning, sir.
Good morning. Thank you for what you and your staff and your team do. You're a blessing to Wichita and our community. I congratulate you on your appointment into the position and look forward to all the great things that you have to offer to the city. More of a comment, because some of the questions that I had that I wanted to raise have already been asked and answered, but more of a comment to the committee, just to let you know that I was personally affected by me and my family by what's going on, what we're talking about here today. So I appreciate, and I know how hard it is to herd kittens and get people to actually talk. So I appreciate both yourself, the utilities, everyone who's represented here today, just having the gumption and the good common sense to enter into negotiations faithfully and talk. Because many of you know, as you saw from news reports, many folks, I think about all folks from my side of the aisle, were approached by some culprit, still under investigation. So I'm not going to matlock you and discuss ongoing litigation or anything like that, with white powder, and sent out some folk to run up on individuals, family members, to include my own. And we did not have the ability to find out who that was. Could you explain to the committee, in the absence of this particular negotiation that you have right now, as generally as you can, without giving away, the secret sauce, what type of tactics would you utilize in absence of this particular offering to help someone like my wife and my kids find out who it is that's coming to offer them violence in Wichita? What exactly would you do?
It would be a far more time-consuming process, and it might be a futile one, to be quite honest with you. We still go door to door because we want the community to know that we care, and that the discharge of a firearm in their neighborhood will not be tolerated. But it would require simple, I've been doing this a long time, longer than I like to admit. And I realize I remember back when we did not have this technology, things took a lot longer. And that is why clearance rates were not at 95% years ago, because we had to rely on the fact whether we had a witness and someone willing to come forward and cooperate. And often people were cooperating, but you simply cannot distinguish a vehicle. This is never going to be the one point of contact that one point of data that results in an arrest. This is just but one very small piece that puts us in the right direction, but it's a very important and time-consuming piece. And that's why, if we went through just the homicides this year in Wichita, you can see why those were solved in the very same day, and most of them were solved that quickly because of the direction that we got from this type of technology. And when it comes to prosecution, the fact that we can put someone in a location when the crime occurred is vitally important to a successful prosecution.
Absolutely. And just for a quick follow on, thank you for that, sir. The competency, the character that your department holds, I definitely appreciate. I certainly applaud you. And again, I want to thank all the other members who have entered into this agreement with you for taking the time to consider it faithfully and help to protect not only my family, but the families of others here in our community that they also serve. I think that it goes a long way to say that we, need to discuss some of the things that are raised here and some of the other testimony. But I look forward to hammering this out. Thank you, sir.
Thank you, sir.
Thank you, Representative Melton.
Thank you, Mr. Chair. Thank you, Chief, and your staff for everything that you guys do. I have a question. You said that the data is maintained for 30 days. Is that adequate time? Because, it could be a year or something go by and it all start to click and come together, and that data is erased.
Well, ma'am, Representative, it's the compromise. I mean, the other representatives that have a different point of view, but they do have valid points. So when these policies were crafted, it was understanding the fact that, we have to acknowledge the concerns for privacy and the retention of data. And our experience is, and I think this year, again, just talking about homicide proves that 30 days, I think, is sufficient for law enforcement. And it also deals with a lot of the privacy concerns and data retention concerns that people have, to know that 30 days and that information is destroyed completely. So 30 days, I think, is enough for law enforcement.
You're the expert. Thank you.
Thank you, ma'am.
Representative Roth.
Thank you, Chairman. Thank you, Chief. Is this the same technology that KTA is using? Kansas Turnpike Authority is using on the.
Well, they use a version of ALPR technology. Yes. So when you that's how you get the ticket in the mail if you go through without paying your bill. So they read the license plate and they go into the database and look up your car and your address and send you a notice.
In regard to data, I know that you say you only keep data 30 days and it's gone. I could almost promise you the data is never gone. And so you may not have access to it, but to your question, the data is always going to be there. And that's from a background of many years. So, but thank you for what.
That's above my level, but what I can promise you is that we cannot access that.
And that's what I said.
Law enforcement, yes,
you may
sir.
not be able to access it,
right?
But the data is still there. If they had to go back a year or 2 or 5 and look at data, but they may not have access to that. And then the amount of data that they're keeping is probably terabytes. It's probably why they need to flush it every 30 days, because you take of all the tags that they're taking pictures of, it takes up data space, and that data space is just huge, and that's going to fill up forever. I mean, and depending on your traffic load, I mean, you may have to do it sooner than that. Thank you, Chairman.
Let's go over to my ranking member, Mr. Hobson.
Thank you, Mr. Chairman. Thank you, Chief, for being here for your testimony. Basically, I just wanted to follow with Representative Rod in regards to the 30-day window in terms of access. Do you verify every 30 days? Do they send you a report that data has been, deleted? What's the verification per se in regards to, because
Flock?
Well, yeah.
The only verification that I've had is when I've searched for data post 30 days and it doesn't exist. I have actually reached out to them to see if data is still available for homicide investigations, and it's not there for them after we've developed a suspect and our data is gone. It's gone.
Because you did actually emphasize, privacy, and to what Representative Proctor talked about, civil liberties as well. That is huge. My only hope is that, it is actually whoever's verifying this, making sure that we're not violating anyone's civil rights per se by keeping all this data in there. No one people who don't have shouldn't be accessing this. Have hands on it. That's where I'm trying to get at.
We would certainly be happy to reach out to Flock and provide more information on how that is purged.
Okay. And one last question, Mr. Chairman. With respect to all the data that you guys are receiving, are the servers actually located here in the state of Kansas?
It's cloud storage. Where it's cloud storage. Flock has cloud storage wherever.
Right. Is it located? Is the data all the data that's collected? Are the servers located within the boundaries of the state of Kansas?
I can't answer where their servers are. I don't know, nor would I even assume that they would disclose that.
And therefore, has there been any unauthorized breach with respect to not just law enforcement? Say, for instance, any hackers that tend to breach that server per se. Is there any report that's been reported back to the police or that you're aware of? Or
no, nothing I've ever heard of as far as a data breach.
Okay. That's all I got. Thank you. Thank you very much for the test. Thank you.
Thank you. I don't see any other questions. Okay. Chief Sullivan and Sergeant Safras, I really appreciate you making the trip up. We've had some good discussion here. If you're pleased to hang around, and I'm sure there'll be more questions afterwards, but thanks for being here.
Your time today.
Next up, we've got Ed Klump with Kansas Association of Chiefs of Police. Welcome, Ed.
Thank you, Mr. Chairman, committee members. My name is Ed Klump, and I'm here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. We wanted to appear in support of this bill just to express that this is not just a Wichita issue. This is a very critical tool for law enforcement now across the state, especially in the metro areas. And the success stories that Chief Sullivan related to you, I have heard similar stories from the Kansas City area, from various places around the state that are using this technology. It's very important that law enforcement be able to adopt technology, but we also recognize how important the balance is between the security of that data and the responsibility we have to not jeopardize people's civil rights regarding, their whereabouts and travel. So that work is, I don't think, ever done, but we're all very conscious of that and try to build that into our policies and procedures. The provisions of this bill we think are very good in putting into place something that generally is practiced and has been practiced for years. We were putting cameras on utility poles when I was still in law enforcement, and that's been quite a few years ago now. And so it's not new. What is new is the technology behind, like the license plate reader systems and things like that. And it is a force multiplier. And we are, like everybody else, we're short on help. We're long on calls and requests. And so anything we can do to help with that force multiplier is important to us. We believe one of the big advantages of this bill is that it puts in place this requirement that we work with utility companies, and there's agreement with utility companies so that they're aware when we are on their property or their poles, they have to be aware because we have to have this agreement with them. And so I think that's an important feature in this. I think that's important for the safety of the line workers and everybody involved. And I can tell you, I've had several experiences here in Topeka of not law enforcement, but just people climbing up utility poles to tap into the power lines so they don't have to pay for their electricity. And many of those don't have good outcomes. And it does present a danger to everybody involved in having to fix those issues. So we think this is a very reasonable bill. We think the things that Wichita has worked on this is functional across the state. And we just want you to know this is a statewide issue. It's not just a Wichita issue. It's very important to us in being able to solve these crimes. Some of these crimes that Chief Sullivan was talking about, when you take a homicide case and you solve that within hours and identify that suspect, not only are you protecting more people that potentially could be harmed, but at the same time, you are saving a tremendous amount of man hours in investigative work that would have taken us perhaps to the same place, and perhaps we would have never got to the same place. And so it's just a critical piece of equipment. And with that, Mr. Chairman, I'll stand for questions.
Right. Committee, any questions for Mr. Klump? Representative Penn.
Thank you, Mr. Chairman. It may be for the revisor as well, but thank you, Sheriff, for coming by today. We appreciate your testimony. When we talk about the Google Earth car that runs around and has all the cameras and everything on it, and I want to be sensitive to what some of my colleagues are raising, justifiably concerns of unreasonable search and seizure. Is there an interest, to your knowledge, of an expectation reasonable for privacy where these cameras would be? Is it the equivalent of being out in public in these public thoroughfares, as the bill states? Do they have that? Is it going to be an unreasonable search on their persons or anything?
It's my understanding, and I'm not an attorney, but it's my understanding there's case law that's been developed over the years what can be in view of these cameras. The LPRs are very unique because they are capturing that, they are focused on that vehicle and not on the surrounding area. There's other types of cameras that are used in some types of investigations that might capture more than that. But when that starts encroaching upon private property that you normally couldn't see from a public way, then there are requirements that we would have to have a search warrant, or if we had to go onto private property to put a camera up, that would require a search warrant. So there are some case law. I'm like I said, I'm not an attorney. I can't go into specifics, but that's what we have in our training.
You betcha. Any other questions? Okay, quick question, Mr. Klump. And I don't expect exact dates, but how long has police been putting cameras on poles or LPRs out on poles, or the things that we will be using here?
Well, the LPR technology has probably been around for, I'm going to guess, maybe 20 years. But like all technology, it was very not very robust in the beginning. And the systems that are out there now, I think, have probably developed over the last 5, 6, 7 years.
There's been a lot of changes, but roughly.
Yep. Yeah.
I apologize. The LPR technology has been around for probably 20 years.
So about 20
in use. But as far as cameras, like he was talking about.
I mean, we were putting cameras on utility poles in the late 80s and early 90s in street drug trafficking and some investigations like that. But they were
40.
They were rare, and we didn't use them often, but they were important to us when we had them. So that type's been around a while. LPRs is the technology where we're able to like pull the data together and find the suspect within hours is probably relatively new when you talk about this stuff.
All right, thank you. Next question to Nick, if I could. What does this bill do? What is the purpose of this bill? Is it to allow them to put 40-year-old technology out there, or is it to indemnify the utilities who own the poles?
I think some of that language that's in there about indemnification and putting utilities as essentially instrumentalities of a governmental entity under the Tort Claims Act just to protect the utilities in their function or in their allowance of law enforcement's use of the utility poles. But it's also to provide the kind of a structure for the agreements that would be made between law enforcement and utilities to allow for these pole attachments to be made.
Okay, thank you. I just wanted to hear that again. All right. Any other questions? Representative Schilling-Siepen, and then we're going to move on.
Just one final general question. Law enforcement equipment. We've heard a lot about cameras, but of course, technology always evolves. So are we also talking about audio surveillance equipment? Are we talking about all kinds of other things that may emerge in the future? I mean, it seems to be a very general, not well-defined term.
Yeah, it was general intentionally. So potentially it could be Raven gunshot detection systems. And we already have, as I went through the number of Gen 10 cameras that are up. They're not covert cameras. They're easily seen by the public. And they are the standard cameras, usually 4-way cameras that are recording. But again, we have the same retention policy on that as well. And then you have the flock camera technology where they're taking pictures of vehicles as they go by, not taking, video. Like the Google Earth was a prime example. It's not that type of camera. It's not really 40-year-old technology. It's how that technology has evolved over 40 years. So you take the ALPR technology and the use of high resolution cameras. So we get a picture of a license plate and are able to also get a good picture of the vehicle as well.
Thank you, sir. My question was really kind of more directed about what the definition of the term is, and that we're aware here that it could mean all kinds of things we haven't discussed here. So I just wanted to make clear that the language of the bill leaves.
It is a generic term.
Thank you.
Okay. All right. Thank you again, Chief.
Thank you.
So Let's move on here. Is there anybody else wishing to speak for a proponent on this? I cannot hear you. Okay. I see no other proponents. Let's go on to the opponents. Do we have any opponents? And I understand that Evergy would like to talk as a mild opponent. Okay, so you're just, okay. I just didn't see you as, see your written only or no comment at all. Okay, all right. Anyone else would like to speak as in opposition? Okay, neutrals, we have Kimberly Savati with Kansas Municipalities. Welcome, Kimberly.
Good morning, Mr. Chairman and members of the committee. I appreciate the opportunity to be here before you this morning on behalf of Kansas Municipal Utilities. And just upfront, we are absolutely not against this bill. We are neutral on this piece of legislation. But we are the community-owned utilities. And so when City Council has a meeting, there are multiple different divisions within local government that report in those city council meetings. And the city utility is one division and law enforcement is a division. And this bill, to be clear, has statewide implications. We were not part of the conversation in the drafting of the legislation, and I'm not criticizing that process, but because it has implications on all of our 118 municipally owned utilities, we do feel that there are a few points of deliberation that this committee may want to take into consideration. So first and foremost, again, we are not opposed to this bill. We are not opposed to law enforcement and law enforcement's efforts. We have a very profound personal story where this situation may have actually, crime against our family may have been resolved more swiftly, but had this technology been available in Topeka or deployed in Topeka. We strongly appreciate that this bill is permissive in nature. It is a may versus a shall. So again, that's demonstrating that the law enforcement may install the technology on our power poles. So that is very appreciated. The term law enforcement equipment is undefined. So for us, does that mean video surveillance equipment, controlling traffic radar, traffic enforcement, or other types of equipment? So again, when we are in a city council meeting, we need to be able to provide that detailed information, law enforcement, to the sister entity, the utility. It's important that the utility be able to review the following information. So the type and the size of the equipment to be installed, any power requirements that such installation would need, and whether that electric service should be available immediately, included at the time of installation, and then where on the power pole that equipment is going to be installed. So as a general rule, we the linemen on the utilities, we install the equipment that's going up on the poles for, again, kind of liability purposes, just to ensure that whatever is being attached to our poles is attached accurately. And so that is a consideration. And then of course for us, non-discriminatory access is important. So if we aren't charging a fee to law enforcement, then does that raise a challenge with other entities that are attached to our poles? And then lastly, indemnification is very appreciated, of course. We do know that in the definitions of expenses and items to be recovered, it lists maintenance and costs for attachment, but it doesn't list our ability to recover costs for operating the equipment. So that would be just a point of consideration. Again, not opposed to the bill, just as we read through it and knowing that this has impacts on 118 of our municipal electric utilities, just a few points of consideration. Happy to answer any questions.
Okay, any quick questions, committee? Mr. Carmichael.
Thank you, Mr. Chair. Hopefully 2 real quick questions. First, we sometimes establish legislative intent in hearings like this. So when the court looks to see what may means, okay, your interpretation, and I think mine is as well, or vice versa, is this says that the utility may, in other words, they may choose to enter into an agreement with a law enforcement agency. But as you interpret this, the utility also has the right to say, this is too dangerous for our line people, etc. No, you cannot use our pole. Is that your interpretation, or do you interpret it that upon application, you have to grant access?
If it were Shell, myself and our legal counsel believes that the Shell does not offer much wiggle room, but the May does afford. It makes it more permissive in nature.
Okay. The second question is, as I look at this bill, I don't see any provisions or requirements that would deal with abandoned equipment. Flock, the company that does these things, as far as I can tell, under the words of the statute, can put their stuff up and leave town and leave it there forever, dangling from the pole. Do you see any requirement, at least in the statute, that would require some sort of obligation on the part of the city and or its contractor to get this stuff off the pole when they're done with it? Because I didn't see anything about that.
Let's see. There is language in here about accessing, operating, and removing the law enforcement equipment, and that's just from a safety specification standpoint. I'm just reviewing this real quick.
It says you may assess a charge.
Mhm.
So presumably then it's in the access agreement if it's going to be there at all.
I would presume.
The agreement between the utility and the law enforcement agency or the contractor, Flock, or whomever it is.
And yeah, I believe that would be the case.
Because I know it's a problem in my community, in my neighborhood, with abandoned equipment still yet hanging on utility poles years later. Thank you.
I don't see any other questions. Representative Schlangensief, you had a question earlier that I was thinking maybe would refer to Evergy. Are you interested in repeating or not?
I think maybe the question's already kind of been answered. I was wondering who does the installation and maintenance of the equipment, and it seems like apparently in some cases it's the line workers who are doing the installation rather than the law enforcement department or the camera equipment installers.
So as a general rule, from a community-owned utility standpoint, we partner with the entities that are seeking to install, and generally we like to participate in that process to ensure the safety of our line workers.
And since the opponent testimony is strictly written here, I wish they would have come and spoken to this so we could have asked. The question is, they imply that there's a risk to the line workers, making them, sensitive to maybe folks in the neighborhood who don't want to be surveilled or something like that. That they might be running some kind of risk by installing this equipment. Maybe I misunderstood that, but that's how I read it. And I'm just curious if anyone knows of any cases where line workers have felt this was somehow an additional burden upon them from a safety point of view.
Welcome, Chuck. Please state your name and who you're with.
Chuck Casely, and with Evergy. To answer your question, I'm not aware of particular incidences where our line folks have been threatened or menaced as a result of installing cameras. I think a general concern would be, though, if this becomes a lot more pervasive and people understand what's going on, that could become an issue. And with respect to who is allowed to install these things, we do have non-line people attaching things to our poles, but they have to be qualified to work around electricity, so they know not to get into the supply space and don't risk harm to them or somebody else by putting something in or close to the electrical lines.
All right. Thank you for taking the question, Chuck. All right. Any other questions? Not seeing any. I do have a couple items of written only. One was an opponent, IBEW local unions 5304, 1464, and 1523. And then we've got a neutral written only, which is from Reagan McLeod, Kansas Electric Co-ops. We also have one from Laura Lutz with Evergy and KDOT. KDOT is in person. Where is KDOT? I will give you a chance to speak before we close it then.
Good morning, Mr. Chairman, members of the committee. My name's Jolene Savage. I'm the Chief Counsel for the Kansas Department of Transportation. And while I'm here today testifying neutral, I want to say that that word gives me pause, because KDOT absolutely wants our colleagues in law enforcement to prevent crime, investigate crime, and secure our state and its citizens. Whether law enforcement is allowed to do this is your and your elected colleagues' decision. If you allow it, KDOT asks that we be allowed to do our job. And our job is to protect the members of the traveling public and those persons working on our right-of-way. And these utility poles are located on our right-of-way as well as the right-of-way of other public entities. Currently, by statute, by process, KDOT gives permits for any installation on the right-of-way. And that is to protect the traveling public, because we don't want something out there that could go through the windshield of a wayward car and hurt the driver or passengers. We don't want something that our maintenance crews may be digging, cleaning out a ditch and hit the power supply, and law enforcement can't get the information they need because we've cut their power off. We don't want our maintenance mowers hitting it. We have provided an amendment to the bill that basically says you still got to get your permit from KDOT if you're on state highway right away, and you still need to follow whatever the locals' procedures are, if any, for their permitting process. I believe we provided that amendment. It's short, about 3 sentences long. I'll stand for questions. I know we're short on time.
No, I appreciate that. I know you do have an amendment floating around out there. Typically, we hear amendments when we're actually working the bill. At this point, we're just hearing it. I'm happy to pass it out at this point if you want, but it normally goes out when we're working the bill. Let me know.
I can just tell you the amendment just says if you're going to do this, you need a permit from KDOT. It's on state highway right away, and you need to follow the locals' procedures, if any. Because I don't know what their procedures are.
Cliff Notes version of the amendment. I have read it. Okay. Committee, any questions? Go ahead, Representative Carmichael.
I haven't seen the amendment, but does it retain to KDOT the right to say no, or does KDOT have to say yes when these requests are made under your amendment?
Our amendment doesn't say we can say yes or no. Our permit process, if they would come to us and say, we want to put one here and we feel that's a danger to the traveling public, we would say no, but let's find another location where this could work and serve your purposes and maintain the safety of the traveling public and our workers.
Thank you, Mr. Chair.
Okay. Quick question I've got to you on that permit is not so much the amendment, but if we've got law enforcement comes to you, they need a camera up somewhere or an LPR or what have you, how long, what is the turnaround for that permit? If we've got something going down in the next 24 hours, I don't want to be waiting 6 months for a permit.
It is my understanding our general turnaround time is 1 week. 1 week. I have just been whispered to this morning as we heard this discussion. If there's an emergency, we need to put one up Saturday morning because we got something going down and KDOT's not available. We don't work 24/7. Get it up, come to us after the fact. We'll make adjustments if needed.
Does that need to be reflected in the amendment?
What do you think?
And I don't need an answer.
I mean, that would just be a process we'd try to work
Just
through.
a question I'm going to throw at you right now, and I don't need an answer, but it's something that I would be looking at if that amendment comes when we work the bill. Okay. Any other questions? Representative Penn.
Microphone.
Hang tight a second, Rep.
We do a similar process for the municipalities that have water systems that break. They have to get out there and fix that water line. You know, take care of the break, take care of the emergency, talk to us afterwards.
Okay, fair answer. Pardon? Oh, I'm sorry.
Dale Kermer.
And you're with?
Department of Transportation.
All right, thank you. All right. Okay, not seeing any other questions?
You said you had two? You said you had two questions.
No,
that was one?
I was curious about the time that it took.
All right.
I was thinking, do we put another amendment out there that it stipulates you shall provide this permit within a certain amount of time? I don't know. It's something I'm thinking on. So, all right. No further questions. Go ahead, Rep. Ben?
Thank you, Mr. Chairman. I'd be amenable to getting with them offline to talk
That's
about
fine.
that language, because I don't want to have anything from KDOT that is prohibitive of getting this work done, but definitely collaborative in that space that's amenable to them, but also responsive to what law enforcement is trying to do. So thank you for that, sir.
Okay. I don't see any further questions. Thank you for your testimony. I'm going to go ahead and close the hearing on, what is this, House Bill 2589. Just watching the clock here because we've got a couple more to go here. Would like to open the hearing on House Bill 2590. If I could get the reviser to explain the bill to us. Thank you.
Yeah, thank you, Mr. Chairman. So House Bill 2590 would amend current law, KSA 66-151, to update the maximum penalties that may be imposed by the State Corporation Commission for the pipeline safety violations. These penalties essentially would be updated to reflect some updates that were made in federal law a decade ago or so under a federal statute, which increased the maximum penalties that may be assessed pursuant to that federal law to $200,000 per violation per day, with a maximum of $2 million for a related series of violations. So this bill would essentially update the state law to in accordance with that federal law. And I'd be happy to stand for questions.
Committee, any questions? Okay, so would I be correct in just saying this is a technical correction to put us in with federal law?
I'm betting Leo Hanos behind me will probably answer your questions on that topic right there.
Thank you, Nick. First up is Leo Hanos with Kansas Corporation Commission.
Thank you, Mr. Chairman. Good morning, members of the committee. I'm Leo Hanos. I'm the Chief Engineer for the Kansas Corporation Commission. And I'm appearing today on behalf of staff to support House Bill 2590. As Nick mentioned, it does update the penalties that we have in our state law to match what is in the federal law. There's another underlying reason to this, though, and then I'll go into that a little bit. Pipeline safety law is a federal law. It was written in 1968 in the Natural Gas Pipeline Safety Act, which gave the United States Department of Transportation the authority to write regulations and to enforce them throughout the nation. However, the Pipeline Safety Act also includes a clause, which is in paragraph 6105, which says the states, you can have primacy over these laws if you will take them into your regulations, and you will also meet certain conditions that are listed in this paragraph 6105. And I bring up the paragraph because that's what they know it as. It's a 6105 program that Kansas has become. Kansas has had adopted federal laws since 1970. We were actually enforcing pipeline safety rules in the early 1960s by adopting what was called the Association of Society of Mechanical Engineers piping codes into our law. One of the various conditions to meet a 6105 obligation is you have to have penalties, maximum penalty levels that are essentially the same as in the federal law. And it's important to note the act doesn't really require the feds or the state to penalize, to write fines to this number. This is just a maximum level that is set in the law. I will also note that every 4 years, as Congress is wont to do, they will update or reauthorize the Pipeline Safety Act, and they'll update these rules. So they've changed these penalty levels over time. Kansas in 2012 partially adopted what the federal requirement was for us, but we left the single violation number alone, which is $25,000 as a maximum. That actually dates back to Congress's requirement from 1991. Now, the part of DOT that's responsible for enforcing pipeline safety is known as the Pipeline and Hazardous Materials Safety Administration, or PHMSA, and we say PHMSA. That's what we'll call them. PHMSA has notified. Well, actually, they've approved our certification every year. But they've always said, you've got to get with the legislation and get this fixed. We're one of maybe 20 states that has not met that requirement, by the way. So we have done that over the years. 2012 is the last time we made a change to it. We tried again, I think, in 2018 or 2020. We weren't successful at that legislation. So we've gone on past that one. Recently, in 2023, PHMSA notified us that our underground natural gas storage program for inspecting storage facilities will be converted to a 6106 program. Well, 106 is the paragraph in the law that says you can be a PHMSA contractor, basically. We can go out and do the inspections, and all the enforcement has to be turned over to PHMSA to complete the enforcement activity they want to do. They've sent us a letter just a couple of months ago telling us the same thing, which says that for the rest of your program, they're warning us that that has a real strong possibility of being converted to a 106 program as well. It doesn't affect our funding. I mean, we'd still get reimbursed for about 80% of the program costs. We would just lose the enforcement authority over state interstate facilities. And one other thing to note is that under 6106, of course, PHMSA would then have the maximum civil penalties that they could enforce. Those levels are actually higher than what's in the Pipeline Safety Act because of another federal law called the Civil Penalties Inflation Adjustment Act Improvements Act of 2015. Basically, that law makes every federal agency have to increase their maximum penalties according to inflation. And in this case, PHMSA's law, which changes every year, is now set at $266,000 per single violations for maximums and $2.6 million for related maximums. And that's established in it's every year they publish it in 49 CFR Part 190. So in summary, KCC staff supports the approval of 2590 in order to maintain our 6105 status primarily. The proposed amendment does not require the commission to impose civil penalties. Instead, it simply sets a maximum penalty that can be levied for violations of the Act. Without the approval of 2590, KCC may lose the ability to issue any civil penalties or even resolve pipeline safety violations with Kansas operators. And instead, that enforcement authority would be transferred to PHMSA. And we have about 125 operators that we inspect across the state. They're not all large. Kansas Gas Service is the largest with well over 650,000 customers. They range as small as small towns, 115 customers. We work to get them into compliance. We don't use this penalty very often, or we have never hit a maximum penalty. I think the largest I've ever seen was probably the 1990s at 300,000, and that was adjusted when they did the work they needed to do. One other thing about state authority that the federal level does not have is that we have the ability to take a penalty and direct it to other causes. We're in the process of doing that right now. We've taken a $158,000 penalty, and we're directing it to 3 colleges to enhance their heavy equipment operator training program to minimize damages to pipeline safety from third-party damages and one-call violations. So that's the ability we get under state enforcement that we won't have if this becomes a federal enforcement level. That's all I have, Mr. Chairman. I'd be happy to answer your questions.
Committee, any questions? I do not see any. Thank you, Leo, for being here. Would anyone else like to speak to this as a proponent? I do not see any. I do not see any other opponents. I do not see any neutral, unless anyone would like to speak. And there is no written testimony on that. So with that, I will close the hearing on 2590. Let's move on to 2597, extending the timelines for the State Corporation Commission to make determination regarding a rate-making treatment for electric generation. Nick.
Thank you, Mr. Chairman. So Committee House Bill 2597 would amend current law KSA 66-1239. What this statute does, it authorizes a public utility to seek a predetermination of rate-making principles and treatment when a utility is going to undertake construction of, or planning to undertake construction of, or acquire a stake in an electric transmission facility or a generation facility. So currently under this law, the commission is required to issue an order once a utility seeks this predetermination of rate making, and the commission is required to set forth an order on the predetermination decision within 180 days of the date that the utility files its petition. And then in the law, if the commission does not issue an order within that time frame, the utility's proposed determination of rate-making principles is deemed to be approved by the commission. What the bill would do is it would extend that 180-day period to 240 days to give the commission 240 days to act on those predetermination hearings. And I'd be happy to stand for questions.
Thank you, Nick. Any questions for the reviser? Not seeing any. Thank you. First up, I would like to call the proponent, Paul Snyder, Kansans for Lower Electric Rates. Welcome to the committee, Paul.
Good morning, Mr. Chairman, members of the committee. My name is Paul Snyder with Kansans for Lower Electric Rates. I'm the one that introduced this bill, and was intended to be short and simple, and probably the design was be perhaps the least controversial bill we've ever introduced here. Hopefully, we'll still get to that point, but this was good-hearted in nature, and I know Mr. Case was getting up, and I glanced at his testimony. He raises some good points, so I think there's a middle ground here. But in general, this statute was put in place about 20 years ago when it was designed when a utility was going to go in and make a very significant investment. They want to have certainty for how the commission's going to treat that. So don't have an issue with the concept of the statute. It's been used a handful of times, notably for the Lacine power plant retrofits, and also for, I think it was used for the consideration of closing the Lawrence coal plant just in the last year or two. But and as Nick explained, all we're trying to do is take consideration of that case, take it from 6 months to 8 months. That's the time period allowed for a rate case which many believe is also on the short side, much shorter than the timeline afforded in Missouri. And the reason for this is really pretty simple. When we're talking about using this statute, what we're talking about is using it for things like closing plants. The securitization statute passed a couple of years ago was tied to this. But also, you heard on Tuesday, the desire is to build a new gas generation plant. That could cost upwards of $1 billion and be amortized over 40 years. And when you do that, that increases the cost probably close to $2 billion. And an investment that sizable that's going to be there for generations, our point is simply we need more time to process that. The utility has all the time in the world to come up with an application, but interveners have to react within that timeline that's established. The commission could certainly approve shorter timelines, but this would just set a maximum timeline. And with that, be happy to answer any questions. I would note, to the extent I don't have any questions, that I have a parent-teacher conference at 10:40. So if you're still here talking about this stuff, please excuse my absence. Thank you.
Well, then I'm going to start with Mr. Carmichael.
Thank you, Mr. Snyder. I don't want to keep you from the parent-teacher conference. I'm sure your children are well behaved and you'll receive nothing but compliments. So I wish you well. This past summer, somewhere during that course of interim hearings, there was an occasion when I believe it was the KCC said there was a particular part of rate making or whatever where they needed some additional, it would be helpful to have additional time. I did not go back and watch everything this summer to find out if this refers to that. And I see a puzzled look on your face, so maybe you may not have the answer.
At that point, I do recall there was conversation about line sighting. They agreed maybe there should be
that's it
to that process.
Thank you. You've answered my question. Appreciate it. Different matter.
Any further questions? Not seeing any. Thank you.
Thank you,
Mr. Snyder. I show written only from David Nickel with Curb. Anyone else wish to speak as a proponent? Not seeing any. Let's move on to the opponents. I'd like to call up Chuck Casely with Evergy. Welcome, Chuck.
Morning again, Mr. Chairman, ranking member, members of the committee. We're softly opposed. I wouldn't say it's uncontroversial, but I agree with the intent, that there's no malintent. Look, I think if you go back and look, most of the predetermination proceedings that we have, first of all, work fine and more time isn't needed. So to just unilaterally say 240 days is which is the same time for a full-blown rate case with, dozens of witnesses, dozens of potentially expert witnesses, and thousands of pages of testimony, whereas one proceeding needs the same time period, probably not the case as a one-size-fits-all universal rule. The flip side is when we did the retrofits on our Lacine power plant from an environmental perspective, it probably would have been useful for some of the parties to have additional time. Look, we came in this session and asked for some reforms be made to the regulatory process. We're going to discuss those tomorrow. I think talking about this in the context of those and seeing if we can't reach a compromise on this is well in order. And in fact, I don't think we would be proposed with giving the staff or the commission some authority to extend in cases like a very large power plant or a power plant retrofit. And so we're opposed as of right now, but can see our path to a compromise on this and look forward to talking to the parties.
Committee, any questions? Don't see any. Thank you. Thank you, Mr. Casey. I see it. Would anyone else would like to speak as an opponent? Not seeing it. We've got no written neutrals. I'd like to call up Jeff McClanahan with Kansas Corporation Commission. Welcome, Jeff.
Thank you, Chair, and members of the committee. Good morning. I'm Jeff McClanahan with the Kansas Corporation Commission. Staff is testifying neutral on this bill. We just pointed out that to Mr. Casey's point here, that on the last predetermination we did was the Lacine Power Plant, and it was in excess of $1 billion, and certainly it was a very tight schedule. And I provided an example of some of the issues by just moving the hearing date. The commission had some conflicts, wanted to move the hearing date up 4 days, and we had to file a request to modify the procedural schedule because we were extremely concerned about the timelines. So there are times where 180 days is really tough to meet. We'll always meet our statutory deadlines, but certainly in that particular case, more time would have been helpful. On the other hand, we've entered into an integrated resource plan process with Evergy now that is granular enough to provide some aid in a predetermination hearing, but at this time we haven't had a predetermination where we could see how much that would help. So with $1 billion gas plant, we're aware of that. We've seen some of the modeling on it, but I'm not sure that it will be enough to squeeze into 180 days. So with that, I just believe that moving to 240 would provide flexibility. And to Mr. Casey's point, we can always, or Mr. Snyder's, one or the other, we can always shorten up that timeline with the procedural schedule if it's a simpler case. So that option's always there. So with that, I'll complete my talk and stand for any questions you may have.
Okay. Committee, any questions for Mr. McClanahan? Let's go with Representative Schreiber.
Thank you, Mr. Chair, and thank you, Jeff. This really doesn't have to deal with the changes to this statute, but in there, it defines transmission facility about existing lines that are 34.5 kilovolts or higher, and then also new lines 230 above. So it seems like, and I know scattered throughout the statutes, there are different definitions for transmission. Does it still make sense to have that 34.5 in there?
Possibly. That can be a transmission level service. It's below what SPP would do. The utility may want to come in for predetermination on that. I'm unaware of any time that has happened, but that might be a question for the utilities to determine whether they would want that in there or not. But I wouldn't want to necessarily take that away from that option.
Thank you. Thank you, Mr. Chair.
Any other questions? Not seeing any. Thank you for being here.
Thank you.
Anyone else wish to speak as a neutral? Not seeing any. I have no written material at all. So with that, I will close the hearing on House Bill 2597. Committee, we're going to meet again on February 13th. We're going to have a hearing on House Bill 2591, which is a COMA bill, 2620 for coal, and 2690, which is the 911 bill. So come prepared for that. Meeting is adjourned.